Hi, this is Paul McConnell from the McConnell Family Law Group, and I'm going to talk to you about how binding arbitration differs from private mediation. You've seen in other videos I've talked more specifically in more detail about both mediation and about private arbitration. I want to compare those so you have a better understanding what the differences are. First, as a refresher, there's really two different types of mediation, and unfortunately they have the same name. So the first is where you hire a private mediator and the parties, they represent themselves. For example, sometimes I'm a private mediator and I act as a mediator and the parties represent themselves. They may have attorneys that help them. They're called review counsel, but they're not with them at the mediation. So that's one type of mediation. That's not what I'm talking about here. That's just entirely different. And the other type of mediation, though, is you have an attorney that you're working with on the litigation model through that pathway towards your divorce. You've exchanged discovery and you started negotiations, but you can't resolve it. So now there comes a decision point where you could either go down and hire a private mediator to help resolve it, or a private arbitrator through private arbitration and try to resolve it that way. So that's what I'm trying to compare to help you get a better understanding. Oftentimes it's the same person that you might hire for the mediator versus the arbitrator. In other words, there's retired judges and they have about 80% of the market share. Sometimes mediation makes sense and sometimes private arbitration makes sense. Now in the mediation, hiring one of these retired judges, typically, but not always, these retired judges to be the mediator, they're going to basically continue with negotiation. They're going to meet with the parties, have a really good understanding of the case. They're going to go back and forth in private settings, either whether it's by Zoom or in person. They're going to go back and forth and get each of the parties to move off of their positions, tell them why, the strengths of their case, the weaknesses of their case, the exposure they have and the like, and get both parties to find common ground. And through that process, if they still can't find a middle ground, if you will, sometimes, often, but not always, that private mediator will make a recommendation. If I were to the judge in this case, this is what I would do. But it's not binding, and that's the big difference between the two. If that retired judge is acting as a mediator, they can make recommendations, but they're not binding and not final. Whereas with binding arbitration, they're not doing that negotiation back and forth and trying to forge an agreement. They're basically just hearing each side, what each side has to say, and they're going to issue a final ruling, essentially, that's going to be adopted by the court as the decision in your case. So there's pros and cons to each of the processes, and we decide them in concert with our clients on a case-by-case basis. And of course, the other party has a vote in the matter as well, because whether it's through private mediation or private arbitration, it has to be done by agreement. That is, you have to agree to the process. So I hope this helps you understand the difference. If you have any questions, contact us.